in the bill. The bill didn't have 3D. It was introduced in Parliament during the voting. It wasn't even before JPC. 3D and 3E. 3D and 3E. Not in the original bill circulated. No discussion, no time for discussion. Not even in the JPC, naturally, because if it's not in the bill, where would it be in the JPC? So these are very disturbing features, Mullah, that...
But even in Parliament, there was no discussion.
I'm sorry?
Even in Parliament, there was no discussion on 3D and 3E.
No, it was just when the final bill was passed, they introduced the amendment without debate. Passed. Suspending the rules, inserted 3D and passed. Because your lordship knows the speaker and can suspend the rules. So introduce 3D, introduce 3E, get it passed because you have majority.
At the time of voting, it was introduced and passed.
Yeah, naturally, at the time of voting, you suspend the rules, you introduce this just before the voting. It can't be during voting, just before the voting. Yes. The question is that, of course, we can never challenge the legislation on the basis of mala fides. Your lordship has held it time and again, Mullah. But these are very disturbing features which ought to be taken note of, Mullah. Of course, ultimately in the final hearing, your lordships will hear us on this. But that's number one. The suspension of rule, Mullah, page number 102. Just note that, Mullah, in writ petition 276 of 2025.
Writ petition number?
226 of 2020, 276 of 2025. First matter, Maulana Arshad Madani. 276 of 2025. At page 102.
Kindly record his statement that 3D was not discussed in JPC. Nothing turns on that, but kindly record it.
Yes, we have recorded it. Therefore, we are recording each and every proposition.
I am saying on instructions, Mullah.
Section 3D and 3 not circulated in the original bill. No discussion, no time for discussion either in JPC or in Parliament.
It's correct.
I'll answer, my lord, whether that can affect the validity of a
So
legislation.
that's a separate issue.
Factually, kindly, my lord.
I'm not saying whether it affects or doesn't. No, I know that, but there is no, in the JPC, 3D is not circulated. I know that. 3D is not circulated. Nor is 3E circulated. Now, it is kindly see 102. May I just read it? Or in the lead petition, page 102. What is the date of this?
This.
Now, kindly see, Mullah, the law minister says that this house do suspend. I of 80. My lord has that? Yes. In page 102. Justice Masi.
You read it out. Sorry.
I'm sorry, Your Honor. So this house do suspend clause I of 80 of the rules of procedure and conduct of business insofar as it requires that an amendment shall be within the scope of the bill and relevant to the subject matter of the clause to which it relates in its application to. Now just note it, Mullah, and they suspend it, and then note the date, Mullah. Wide amendments number list number 11 circulated on 2/4. Losses have that date? And this is cleared on 2/4. Suspended, circulated on 2/4, cleared on 2/4.
No notice to anybody.
This amendment may be allowed or moved.
You give me a copy.
Yeah, I'll give you. No, it's in the petition, page 102. It's page 102. Anyway, just what the impact of that is, we'll see later. Now, just one other thing. Kindly come to 1995 Act for a minute. Just give it the 1995 Act. Yeah. Yes. Now just see that, 2025 Act your lordships may take. I know. Amended by 2025. Yeah. Then if you look at the 95 Act, just look at section 4, Malaj. Survey. That's what you want to show. Show the survey. 1995 Act, survey. So previously, Malaj, the regime was, there used to be a survey. And after the survey, Malaj, the items identified had to be registered.
After survey?
The items identified, that is the Waqf identified, would have to be registered. There was a very, very, very elaborate procedure. Your lordships will have it in the footnote of the 2025 Act. Preliminary survey of Waqaf is removed, Malaj. And if you look at the 95 Act, you will find that there's a whole survey provision. Your lordships have the 95 Act or no?
Yes, we have.
The unamended one.
Unamended we don't have.
Yeah, just give it to my lords.
But then the footnote there is there prior to substitution.
Yeah, but what did the survey procedure involve, Malaj? I'm just mentioning that to you. His lordships have it now. Now, so therefore, what happens is page 6, section 4. So you have to have a preliminary survey of Waqaf. The state government, by notification, appoints a survey commissioner. Then other commissioners are appointed for the purposes of making the survey. Then every state government maintains a list, and the survey of Waqaf shall be completed within a period of 1 year from the commencement of the Waqf Amendment Act of 2013. And if it's not done, then provided that where no survey commissioner has been appointed, a survey commissioner shall be appointed. And then under subsection 3, there's a whole inquiry process. Survey commissioner, after making an inquiry, as you may consider necessary, submits its report. And what is that inquiry? Nature of objects of the Waqf, number of Waqfs, gross income, amount of land revenue, expenses incurred. So there's a whole very, very elaborate procedure. That's all I want to show to your lordships. Now the survey commissioner is over. It's now replaced by the designated officer. The collector now. That's all. The whole process is over. Right? And then let's to section 5, publication of list. So once the survey is done, section 5 of the 95 Act says that list will be published. Yes. And none of this relates to registration. This is to find out what are the Waqf properties in various parts of the country. And then 5.2 will say the board shall examine the report and forward it back to the government within a period of 6 months. And then 5.3 says the revenue authority shall include the list of Waqf while updating the land records. So there's a whole very, very elaborate process. Then comes, section 36 of this very act. Thereafter, the registration is done. Yeah, then 37. नहीं कोई फायदा नहीं, कंफ्यूज हो जाएंगे। Always that is for them to look at me and they look. It's to non-balance. Leave it to me. I have some experience. जब लिखते हैं
Section 36 of 95 Act.
Yes, of the 95 Act. So there's a survey procedure, then there's a list that is prepared, and then the registration happens, which is under 36. 36 says every waqf, page 27, whether created before or after the commencement, shall be registered at the office of the board.
Registration is not introduced for the first time in this act.
No. It's been there. It's been there for a long time. I told your lordship right from 54. Just the consequence is only quay the mutawalli. And earlier also surveys were done. Survey was introduced in 64, Malas. Registration was in 54. Survey was introduced in 64. And that's constantly been happening, Malas, under every subsequent act, Malas, we amended. Then, Malas, the decision if a property is waqf property. Then, Malas, the board itself, section 40. So whatever is surveyed will be registered. For what is left out, the board itself can collect information. And that's section 40. This also removed. Survey removed. Registration requirement remains. 40 removed. Board has reason to believe that property, if any, arises whether a particular property is waqf property or not.
You're reading?
That's 40, section 40. And the board was given the power to decide that question on its own. Why? Because the board were consisted of Muslims and elected. And they could call for information and decide if it's left out anywhere. So that was the regime, Malas. Now that's all done away with. Now the power is with the collector. So collector will, what surveys will the collector do, Malas? No, 37, 7A. Yes, I will. Now let's connect this to section 36, 7A of the present act, of the 2025 Act. And 36(1) says, every waqf, whether created before or after the commencement, shall be registered at the office of the board. That's 36. So, Malas, and then, Malas, subsection 7 says the following. At page 34. So it shall be registered, and on receipt of an application for registration, the board should forward the application to the collector. So your lordship knows then, Malas, that the survey and all is over.
You're reading section?
Section 36, 1 and 7 of the amended act.
The amended act.
Yes. So 36(1) talks about registration, no? Every waqf, whether created before or after, shall be registered. And then 7 says at page 34, Malas, on receipt of an application for registration, the board shall forward the application to the collector, having jurisdiction to inquire into the genuineness and validity of the application and correctness of the particulars therein, and submit a report to the board. So, Malas, all the survey procedure is just given a go-by to. 7A. Yeah. It's all being recorded in any case. 7A says where the collector in his report mentions that the property wholly or in part is in dispute. Now let's connect this to 3R and 3C. Connect this to 3R and 3C. Can be any dispute. So where the collector in his report mentions that the property wholly or in part is in dispute or is a government property, the waqf in relation to such property shall not be registered. Somebody says this is disputed, even if I want to register it, I can't. Called wholesale takeover, Balads, of a community's right. Wholesale takeover. I'm going to. Really. 8. Section 8, I'm sorry, Ms. Justice Massey has that. It says, in the case of Awqaf created before the commencement of this act, every application for registration shall be made within 3 months from such commencement, and in case created after such commencement, within 3 months of the date of creation. And then 10, Malads, which is very, very problematic. No suit, appeal, or other legal proceeding for the enforcement of any right on behalf of any waqf which has not been registered in accordance with the provisions of this act shall be instituted or commenced or heard, tried or decided by any court after expiry of the period of 6 months. So you don't register me, then I can go nowhere. I can't file a suit, I can't file any proceedings. So my fundamental right to litigate is lost. My property is taken over and I can't litigate on that property. And this is through legislative fiat without a procedure. Nothing can be more violative of 14, Malad, manifestly arbitrary. Now connected to the 83 provision. Designated officer under 3C, higher than the collector. If he says it's in dispute, it's government property. Right, Mulaj? Then that dispute, Mulaj, takes away the character of the waqf as long as the dispute is pending and his report is pending. And after that, it goes to the revenue records. And then I have to go to the tribunal. But if it's not allowed to be registered, I can't even go to the tribunal. Because no suit, no proceeding shall lie. And connected to 3R then, because 3C deals with government property and government organizations, panchayats and all. 3R says any dispute. So the consequences of this act are take over the property of waqfs, take over the community's property, and then don't allow them a remedy also. And by the time the aggrieved party in a particular case goes to the tribunal, then 10 years will pass, and that's the end of the matter. So therefore, valuable property across the country where for charitable purposes, religious purposes, mothers is just taken away. The perpetuity of the waqf is lost. And the fundamental of waqf is...
But then, whether this provision, earlier acts, the registration was compulsory.
Yes. Yes.
Oh.
This provision was not there, Malas.
No. So whatever properties are registered prior to the commencement of this act.
It was there, it was not implemented.
We requested you in the beginning itself.
Sorry, my lord, but it's
We requested in the beginning that we will...
something troubling, my lord. Anyway, I'll point out when my turn comes.
Thank you. Yes, Malas, your lordship was saying something.
No, earlier enactment also provided for registration.
Yes.
All such works which are registered prior to this commencement of this act, they would not be affected by this provision. Only such of the trusts which were required to be registered but have not been registered, they have been given a breather of 3 months
No, but if there's a dispute, Maharaj, then that's the problem. Your Lordship is right. But supposing there's a dispute, then what happens?
3D is the retrospective.
3C,
Yes.
And E.
that makes it a problematic. R, 3R, 3C makes it problematic for user.
What is
I'm going to read that.
We have 3 months. There is also an onus on the state government to conduct a survey. If the government has failed to conduct the survey, then why should the community pay for it?
Right.
This image registers they again have to submit the details.
This kind of
But my user is abolished. So, Maharaj, Waqf by user done away with. On the registration part, your Lordship knows registration is required to give the name and address of the creator. I don't do that, no registration. If no registration, no remedy. Where Maharaj registered Waqfs? I'm talking about registered Waqfs now, Maharaj. Your Lordship asked me that question. If registration is done prior, then I have to give this detail, name and address of creator of Waqf. If I can't do that, not registered. Not registered means the 7A and 10 will come in. We'll say this property is in dispute. Apart from that, because 7A says property in dispute. So if property is in dispute, it will not be registered. If not registered, then section 10, subsection 10 comes in. So, Maharaj, where's the remedy? So you can't, Maharaj, put the community in a slot, enslave it, don't allow them any leeway, take away their property, don't compensate because it's private property, it's not public property, it's my property, don't allow them a procedure to vindicate my rights. You don't have to go to the tribunal, that I have to go to the tribunal. Until kingdom come, that matter will not be decided. And I guess I'm being facetious. The same thing, Maharaj, now 3E. Now I've done with 3D, I've done with the others. Now just come to 3E, Maharaj. Same thing happened as far as 3 is concerned in the parliament. 3E and 3D both. Now, Maharaj, I've given to your lordships my submissions.
It's a spiral bound note which I gave you. It's in your lordship's note. This can
I'm not going to read them, Maharaj, because I've argued all that already. So I just want to show you an annexure. My written note. Kindly see page 18
Of your note.
of my written submissions, Maharaj, which has all that I've argued before your lordships is there.
So you want to refer to the spiral one or the
The spiral one.
spiral?
same cheap.
Nothing is the same.
I don't have annexed. I'm not making an issue.
Just give it.
Just give me annexed.
Sure, give it to me. It's there, Maharaj. Page 18. It's part of the submissions.
Responded to this. He has already responded.
No, not this. Oh, you got it without it.
Give me a copy. I'm not raising an issue.
No. Fine. We have another copy. Not an issue. I'm sorry if that's happened. Kindly see 18, Maharaj. These are the list of scheduled tribes with Muslim population. I just wanted to point that out because that's what's reflected in 3E. States, Maharaj. I've set out the states also.
Schedule 5 to 1.
Maharaj, most of the submissions I'm not going to other provisions of the Act because that will require further elaboration. These are per se violations, per se. Miller, then I've done with 3. Just I'll have to read the section. That's at page 10 of your Lordship's book. Notwithstanding anything contained in this act or any other law for the time being in force, no land belonging to, sorry, but it's 3E, page 10 of the Act, 2025, as amended. Notwithstanding anything contained in this act or any other law for the time being in force, no land belonging to members of scheduled tribes under the provisions of the 5th and the 6th schedule shall be declared or deemed to be Waqf property. So I've shown you the list, Mullah, so they lose their status as Waqf.
The 5th schedule
And the 6th schedule. This is per se bad. Then kindly come to section 108. No, wait. Kindly come to 108. Now, this is an interesting provision. 108 deals with evacuee property, a gift from partition millers. Page 79 of the statute that your Lordship has. Now, Now, 108 Malas provision is omitted in this act, which is, we have a look at the footnote, Malas, what it was. This is in the 2013 Act. The provisions of this Act, sorry, Malas, I'm sorry, it's a footnote. The provisions of this Act at page 79 shall apply and shall be deemed always to have applied in relation to any evacuee property within the meaning of clause F of 2 of the Administration of Evacuee Property Act, which immediately before it became such evacuee property within the said meaning was property comprised in any waqf, and in particular any entrustment, whether by transfer or any documents or in any other manner, and whether generally or for a specified purpose, of any such property to a board made before the commencement of this Act, in pursuance of instructions of the custodian under the Administration of Evacuee Property Act, shall have and shall be deemed always to have had, notwithstanding anything contained in any other provision, effect as if such entrustment had operated and vested in such board. So all evacuee property, which is a gift of partition, vested with the board. So now all evacuee property, which is waqf property, waqf, once a waqf, always a waqf, is taken over by the government. Now, Malaj.
No, sorry, please,
No, I won't.
I
Sorry.
didn't get your point on this.
Malaj, 108 is eliminated. It's still evacuee property.
property is gone.
It's waqf property, Malaj, but it's evacuee property. It was waqf, people left. It continued to be waqf property. Once a waqf, always a waqf. So in 108, Malaj, it says that that property, which was always a waqf, would be given to the board. Instead of the administrator, would be given to the board. Why? Because it's waqf property and the board has to administer it. Then 3C will come in.
That may be so.
Yes.
The thing is, it was mandated to be registered.
Yes.
Obviously, if it is registered, then it continues to be a waqf. How does it go back to the waqf?
Evacuee property, Malaj, no, it will not be.
No, it would.
It will go to the custodian.
Every waqf had to be registered.
Right.
So if it is a waqf, it had to be registered.
I appreciate what my lord is saying, but every evacuee property by law goes to the custodian for allocation.
Not relatable to the waqf. As such, the principle is it goes back to the custodian.
Yes. Now, if it's waqf, the custodian will not keep it.
Will keep it. Will go to the
That's
board.
all that I'm saying. I'm saying nothing more than that. It will go.
Yes. Even if it goes back to the board, continues with the board in any case.
That's what we are saying, but it will not happen now
But in any
because
case, if it
3C
is-
will come in.
But any property which is not registered, obviously as a consequence of section 3,
Yes, that's right.
no more be a work. That's your contention.
That's my contention.
You have to hear.
You have to go back to, ultimately, we have to go back to 3C. We have to go to 3R. We have to go to Muller's inquiry. All that will come in, Muller's. So basically, these are all interconnected provisions, the object of which is to take over Waqf properties. That's the object. And through legislative fiat, without a procedure consistent with the law. Well, it's not somebody else's property. That's really the heart of the matter. So, Mullahs, now I've done with all this. There are only two things left now, Section 9 and Section 14.
And 23.
CEO, you've already mentioned. That's not mentioned. Yeah, I already mentioned CEO. Now, Mullahs, now Section 9 and Section 14. Yes. And then I have done, Mullahs. I mentioned to your lordships that Section 9, if we read it now, that's at page 16, will have a majority, can have a majority of non-Muslims. I know. Yeah. Just 95 Act provision, there were all Muslims. I show now, I show.
Yeah, right.
May I, Mullah? Now, let's kindly come to Section 9 and kindly look at the Section 9 as it was under the 1995 Act. And you will find in the footnote, Mullahs, the following members to be appointed from amongst Muslims. You see that at page 17 bottom. Last line at page 16, bottom, Mullahs, prior to substitution, subsection 2 stood thus. Worship has that? Right at the bottom, Mullahs.
So the
Right.
council shall consist of.
Yes, prior to substitution. Right at the bottom in the footnote. That is the previous Section 9, Mullahs. I'm just showing, Mullahs, what the change is. Prior to substitution, sub-rule 2 stood as the council shall consist of union minister, following members to be appointed by the central government from amongst Muslims, namely all of them to be Muslims, 3 persons who are eminent scholars in Muslim law, provided that at least 2 of the members appointed under subclause 1 to 7 shall be women. That's it. So, Mullahs, all of them had to be Muslim?
Judges. Even judges. Even members of parliament and judges.
Even members of parliament and judges had to be Muslim under the previous dispensation. It is true also of all the Hindu endowments, Mullahs. They all have to be Hindu, Mullahs. I've given that in my note also. Now, Mullahs, if you look at the present section, which your lordships will find at 17 top, union minister in charge of Waqf, no reference to Muslim. 3 members of parliament, of whom 2 shall be from the House of the People and Council of States, no reference to Muslim. The following members to be appointed by the central government from amongst Muslim members. So 3 persons to represent Muslim organizations, chairperson of 3 boards, that is 3 by rotation, so therefore 3 and 1, 4. 1 person to represent Mutawalli, that is 5. 3 persons who are eminent scholars in Muslim law, 8. Correct, Malaj? So the total number of Muslim members are 8. D is 2 judges of the Supreme Court or High Court. So therefore 2 there. 1 advocate of national evidence, that's 3. 4 persons of national evidence, that's 7. Additional secretary or joint secretary, that's 8. And Malaj, the first 3, union chairperson and 3 members of parliament, 12. So it's 12 versus 7. So you can have 12 non-Muslims in a situation and 7 Muslims. And the previous acts are all Muslims. So in other words, the administration also is taken over. Proviso says only about 2 members of excluding shall be non-Muslims. So that's the ex officio members. That's right, sir. They provided further that 2 members appointed under this subsection, excluding ex officio members, shall be non-Muslims. At least 2 and up to 12. At least 2 and up to 12.
It doesn't say at least, provided further that 2 members
Appointed under this subsection, excluding ex officio members.
shall be non-Muslim.
That's correct. Excluding ex officio members. So union minister is ex officio. Other may or may not be.
Then how do you say that there would be majority?
Because,
It
Malaj,
says that-
because we are here, we are 10 only, Malaj. 7.
So ex officio would be one. the
Only 1.
The union minister can be both, either a Muslim.
No,
or
it's
not.
excluding ex officio members, it says.
Yes.
Shall be non-Muslim. So it will exclude the minister.
Union minister in charge of the work is ex officio.
Yes, he's excluded, Malaj. He'll be non-Muslim. Then 3 members of parliament.
So the other ex officio is only additional secretary or joint secretary.
That's correct. They'll be non-Muslims, they say. At least 2 of them says, no? Provided.
It's only one
No.
additional secretary or joint secretary.
The above 3 members of parliament also.
They are not ex officio.
No, correct. Correct.
They are not ex officio.
But
So
there are no requirement that they'll be Muslim. That's the point.
let us see, let us read the category one by one.
Yes.
Where the Muslims are
Union minister, will not be Muslim.
either a Muslim or not a Muslim.
No, it says, shall be non-Muslim. Excluding ex officio members.
Where does union minister in charge of work, a chairperson ex officio.
Maybe, may not.
Either a Muslim may not be.
But that's the choice. The point I'm making is that's their choice.
The cabinet doesn't remain same for the entirety.
No. That's not true in any other enactment. Any other Hindu endowment.
So that will examine, but not saying that by this composition, the majority would be
Theoretically. I'm not saying.
Let us examine. So
That's right. That's what I'm saying. Now, let's assume that there'll be non-Muslims. Why your worship is assuming?
let us say union minister in charge of work are non-Muslim.
Non-Muslim. One, 3 members of parliament, non-Muslim. 4.
No. What does it say?
May not be, Malaj.
Maybe may not be.
So I'm assuming, Malaj, they may not. I am theoretically.
Let us see which are ex officio and which are not ex officio.
Correct.
So there are 2 ex officio.
Correct.
One is
Point secretary.
one is J and one is G.
Correct.
One and so assuming that there are 2, both of them are non-Muslim.
Yes, we'll assume that.
Yeah. Then under the proviso,
Yes.
excepting ex officio, there can be 2 members.
No. 2 must be, Malaj.
Better we will call upon you when your turn comes. So don't show the enthusiasm as
Malaj, just
Priyanka is showing that side.
I will make sure that I don't remind you of anything while you're.
Let us read it further.
Yeah.
Therefore, 3 members of parliament, of whom 2 shall be from the house of the people and
Correct.
one from
They
the.
may be non-Muslim.
They may not be.
That's 3. That's 3.
No, not 3. provided that the two of the members appointed under,
House and one from Council of States, so three.
no, it doesn't say, see, provided further that two members appointed under this subsection, excluding ex-members shall be non-Muslim.
Just
So it doesn't say at least,
kindly see,
or,
previous provision said 3 members of parliament shall be from amongst Muslims. In the footnote.
so B could be Muslim, non-Muslims also.
That's what I am saying, but he can be non-Muslim. I am not saying.
So let us see where there is a possibility of non-Muslims being there.
Therefore, the possibility is one chairperson, one, and 3 members of parliament. Possibility of being non-Muslim, that's 4.
Yes.
Correct, Malas?
Then-
Now you come to
Then
the Muslims.
Three is all Muslims.
3 plus chairperson of 3 board by rotation, so 1, 4. 3 and 1, 4 Malas by rotation.
Then one person,
Then 1 person to represent Mutawalli is 5.
5,
3 persons who are eminent scholars in Muslim law, 8.
8.
Correct? Now, correct. So therefore, 8 maximum Muslims. Right?
No.
No,
Minimum.
8 minimum.
8 minimum Muslims. Correct. When I am assuming that all the others are non-Muslim, that's how I'm arguing.
Also,
Eight minimum.
8 minimum.
8 minimum.
Eight
Now,
are
now-
guaranteed.
Guarantee. Well,
Guaranteed Muslim. And let us-
that's the only guarantee we have in this statute. No ambiguity. Then 2 persons who have been judges of the Supreme
No,
Court.
so B could be either Muslims or non-Muslims.
Earlier they were all Muslims.
I agree. I am not disputing there could be Muslims. I am saying we are assuming now that they can appoint non-Muslims, that they are not prohibited to appoint.
No, but let us see. So that 3, then
3 plus 1, 4, Mala. Chairperson plus 3 members of parliament, 4.
let us exclude chairpersons and the secretary.
That's 4 Mullahs. Then you come to 4 persons of national eminence. That's 8.
Two persons who have been judges of the Supreme Court or High Court,
That's 2. Non-Muslims can be.
non-Muslims.
So therefore 4 plus 2, 6.
Yeah.
Then 1 advocate of national, that's 7. And then 4 persons of national level, that's 11. That's what I was telling your lordship. An additional secretary, 12. That's what I was saying to your lordship.
Provided that 2 of the members appointed under subsection C shall be women.
Correct?
Now let us see, provided further that 2 members appointed under this subsection, excluding ex-officio members,
Shall be
shall
non-Muslim.
be not.
Correct?
So the number is restricted to 2. It doesn't say at least 2 or it says there are 2 or more.
It's not limited to 2, but that's the minimum, Maharaj. I mean, the maximum we can have a guaranteed ones are 3 plus 1 plus 1 plus 3. 8. That's all. Theoretical. I'm not saying that they will not be Muslim.
The second proviso, the word used is 2. It doesn't say at least 2.
Excluding, Maharaj. Excluding the exception.
It says excluding 2, so at the most, if this 2 plus 2 ex-officio, it will be 4.
That's correct. That's correct. But they may not all be Muslims, Maharaj. See the previous section in the note, Maharaj, what it was. It's best, we appreciate that, Maharaj. Compare it. Let's compare it. Excluding some shall be not. Yes.
The same people who it's a preceding thing.
Yeah.
All of these were read in the
I'm going to say all of that.
It's clear.
Now see whether the previous provision in the footnote. Now it will make it clear, Malas. The council shall consist of union minister in charge, ex officio. The following members to be appointed by the central government from amongst Muslims. So therefore, 3 are Muslims, 4 are Muslims, 3 are members of parliament
You're
Muslims.
right, Joseph, when you say that all these have to be earlier. Now, the only distinction which has been brought about is that there can be 4 people, 2 ex officio and 2 further people. That's the only.
No, Malaj. No, your members of parliament need not be.
Therefore, maximum, I'm saying 4.
There can be 12 non-Muslims because members of parliament need not be Muslim, Malaj. The proviso, it doesn't say that the rest of them will be Muslims.
Proviso also does not say
Yeah.
Because it is restricting non-Muslims.
I'll let for a moment assume, Malaz, what the observation that's fallen from your lordship is right. I'll assume that, Malaz. I'll assume that for the moment. If it is right, Malaz, then what it means is that they can have at least 4 persons that are non-Muslims.
Yes.
That's what my lord is putting to me. Now, it's a departure from what? From the previous law where everybody had to be a Muslim? Correct, Malaz?
Except the ex-officio chairman.
Yes, exactly. Except that one, everybody had to be Muslim. So they have departed from that entire regime. And your lordships are now interpreting to mean that other than these two, everybody else will be a Muslim apart from the other two.
So because your argument primarily was that the majority would be.
I see. Could be. That's, I still maintain that, Malad. Could be. Unless your lordships were to interpret that in such a way that everybody else has to be a Muslim, which is not reflected in the statute.
No, because the board used this second proviso, provided further that 2 members appointed under the subsection excluding ex-officio members shall be non-Muslim.
Correct.
So if the word 2 members would have been preceded by at least, then there might have been substance in your contention that at least 2 and it can be up to all. Or all those, but it says only.
All right.
It specifies the word 2.
All right. Well, let me assume that. Malad. That's against myself for a moment. Let me
Also,
assume.
we can interpret it in such a manner that
That's fair.
there can't be more than two members except the ex-officio from the non-Muslim category.
Correct. Anyway, according to me, 2 is too many also. But the reason why I'm saying this is that
2 is
in
not too many in 22.
every
2 is not too many in 22.
every religious endowment, Hindu endowment, does not have one person who is a non-Hindu.
Yes. A scholar. If you know the Quran.
Not one person.
You must be aware about the debate going on about Buddha here.
But that both guys, Hindus and Buddhists, both.
They are only Hindus.
Both. The place of worship is for both. Act itself says that. I knew that example would come, Malas. The act itself says that. But that's the only exception, but the act itself says it. In all other Hindu endowment, there cannot be a non-Hindu. Same for Sikhs, Malas. Gurdwara Prabandhak Committee. Nobody can be who's a non-Sikh can be part of it. So why this exception? Assuming, Malas, that we interpret the section in a manner that only 4 will be non-Muslim. We'll assume that. But why should there be 4? Why should they be there at all? If you're giving that privilege to other religious communities, why are you not giving that?
That's a different argument.
I'm putting it like
It's a different argument also.
No, I'm saying on interpretation, I believe, but anyway, that your lordships can do it after the final hearing. At the moment, my request is nothing should be done till your lordship hears all these matters, Malas. Now, it's even worse, Malas, as far as the board is concerned. Now come to 14. Bodh Gaya Act in 11.1, it says Buddhists of every sect shall have, notwithstanding anything contained in this act or the rules framed thereunder, Hindus and Buddhists of every sect shall have access to the temple.
It's a place of worship of two.
Because it's a place of worship of 2 communities, both Buddhists and not only Buddhists.
And the composition is here only either Hindu or Buddhist.
No non-Hindu or no non-Buddhist can go there even. So, Maharaj, that's the scheme of a secular nation where you allow the community representation within the construct in terms of which the...
What are the functions of the council, by the way?
Sorry?
What are the functions and duties of the council?
Advisory functions. Advisory functions.
Are they given a role to
Yes.
interfere in the management of the particular work?
Yeah, your lordships will see. Advising the central government and boards on matters concerning working of boards and due administration of work. Both. That's section 9, subsection 1.
So section 5.
Yes, I'm going to.
Any dispute?
They can issue directives, Malad, the administration of the board.
I will go to the Chief Justice.
And any dispute arising out of the directive shall be referred to a board of adjudication to be constituted by the central government to be presided over by a retired judge of the Supreme Court.
Substantive dispute.
So, Maharaj, these are huge powers vested in the council.
We will call upon them.
That's right. So now, come to now 14 Maharaj. Now, Maharaj, if you look at 14, no election. So all of them, in fact, boards are the entities. Board is the entity which actually administers, and all of them are nominated. Right. I have to read the section, which is exactly the same as the council minutes. The same provision, but except that these are all nominated. Now let's. That's all right, but they will be nominated Muslims. No, that's what I'm trying to say. To
Nominated earlier it said has to have been
like that, I'm trying to say that only. You are insisting on something. Earlier it was elected, now it's nominated. That's all I'm trying to say.
Here there is only one ex-officio.
That's right. That's correct. Only joint secretary to the state government. But all this is nominated. Now let's see the previous section. That is at page 20 minutes in the note. The board or the state for a state and the national capital territory of Delhi shall consist of a chairperson, one or not more than two members as the state government may make fit to be elected from each of the electoral colleges, consisting of Muslim members of parliament. So even members of parliament will have to be Muslim from the state, or as the case may be by the national capital territory of Delhi, Muslim members of the state legislature, Muslim members of the bar council, provided that in case there is no Muslim member of the bar council or the union territory, state government or the union territory may nominate any senior Muslim advocate, mutawallis of awqafs having an annual income of so and so. So, and one person from amongst Muslims who has professional experience in town planning, one person each amongst Muslims to be nominated by the state government from recognized scholars in Shia and Sunni Islamic theology, one person from amongst Muslims to be nominated by the state government from amongst the officers.
So this election is only restricted only to one or two.
Two.
One or two.
One.
So it can be minimum one or maximum two to be elected from four categories.
Number of elected members shall at all times be more than the nominated members of the board. Right, Mullah?
Where did you say that?
At the bottom of 21. Clause 4, Mullah. Earlier clause 4. At the bottom. Last clause.
Page 20.
Page 21. Footnote. The number of elected members of the board shall at all times be more than the nominated members of the board, except as provided in subsection 3.
Of the elected.
And you see here, Malaj, one or more one and not more than two members of the state government may think fit to be elected from each of the electoral.
Yeah.
That's correct.
So there could be one or two either from members of parliament.
That's right.
One or two from the members of state legislature.
Correct.
And a bar council.
Yeah,
And Mutawali.
correct. So the point is, Malaj, one, you start nominating the board, which is the central authority, which administers waqfs. You nominate your own people.
So the power is not with the central government, power is with the state.
State, Malaj, yes. Yes, the government, Malaj. This power is the government, Malaj, either way.
State government.
Nice. Absolutely right. So that takes care of 9 to 14, Malaj. The very scheme of it suggests, Malaj, that you want to exclude us from every facet of activity in relation to the Waqf. So we are here now, Malaj. Anything else? Yes, Malaj, just so that your lordships may note it, I've given at page 11 of my note, Malaj, the spiral bound note, I've given Religious Endowment Acts. Just come to page 11. Ex officio members have to be Hindus there, Malaj. There can be no exception. बोल दिया ना, I see you mentioned earlier.
53.
Page 11, if your lordship notices, Manoj. So, do you want to take a minute? You want to take a minute?
Maybe.
Okay. You will, lordships have page 11 of my note. You will see there Religious Endowment Acts, Andhra Pradesh Act, Tamil Nadu Act, Uttar Pradesh Kashi Vishwanath Temple Act. It starts from page 8. The annexure of it is at page 19, Malaj, of these acts. So all of them, even the ex-officio member, have to be Hindus. The idea is, Malaj, it's not about discrimination. Idea is this is part of my right to manage the affairs of the community. So it's part of 25 and 26. And that is all subject to health, public order and morality. None of this relates to that. Your lordship knows it says subject to public health, morality and public order. What has this got to do with it? So just as educational institutions administer their affairs, religious communities administer their affairs. The Hindus do it, the Sikhs do it. Well, why should the Muslims not do it? Christians do it. And this is not secular. These are mosques, these are activities that are directly, the very creation of the Waqf is not a secular act. The creation of a Waqf is not a secular act. It's the Muslim's property which he gives away and dedicates to God. Somebody else can do the one. You want to do the data, this thing? Huh? It's 116%.
I've got other data.
Okay.
Let's take 5-10 minutes.
Just no problem. Malaj, I'm sorry.
Got it, add karna ho, I can add.
No, I'm not going to. Malaj, just one last thing. They have made a submission, Malaj, that after Malaj, this amendment, in 2013, there has been 116% increase in the registration of Waqfs. And the idea being that how can it be between 2013, there's 116% increase. Right, Malaj? Now we have an answer to that. They have not put it in their written submissions. Now you will deal with it? So my learned friend can deal with it. And Malaj, Dr. Dhawan wants to take a minute, no?
No, just a minute.
Just 1 minute, okay. And then you can do it.
I'll just take.
Okay. I'm deeply obliged to you, Lordship.
Just 1 minute.
Yes, Doctor.
My lord, by straining my voice, I might strain your lordship's ears, my lord.
Sorry, we can put up the mic here.
My lord, traditionally when we joined the bar, there were no microphones. We were taught to address the bar in full throat, my lord. Anyway, just 3 sections that I want to bring to your lordship's notice, my lord.
Now also, when Mr. Ranjit Kumar argues in the adjoining court, we can hear him.
My lord, he's in a class by himself, my lord.
For someone else. Lord, during COVID, when we were appearing virtually, somebody said that, Mr. So-and-so, you are on mute. And I said, even on mute, he is heard.
My lord, just 2-3 sections, my lord, and then I will conclude, my lord. My lord, kindly turn to your lordship's book.
Yes, to make an atmosphere light.
Justice Kuldeep Singh and Justice Verma were the other 2 courts, Lord. And the summer, the court was open, so they were commissioning from inside also, health inside. So of course there was no mic those days, 1996, 97. Both those courts could hear my voice. They had to close their doors and the schools.
Lord, there is a real life story. Mr. Dhawan, Dr. Dhawan would be aware. Lord, once Winston Churchill was sitting in his chamber in the parliament. And in parliament, it is believed, my lord, in those days, that in the lobby there used to be telephones to be used by the members of parliament to talk to their constituents in their constituency. And somebody was speaking very loudly. So Churchill asked him that, who is this man and why is he shouting? His PS said that he is talking to somebody in his constituency. Churchill said, ask him to use the telephone.
My lord, my anecdote is, I told Justice Ramanna, as he then was, that I don't suffer from blood pressure. So he said, you give other people blood pressure, that's the reason why. But at any rate, my lord, levity apart, my lord, may I take your lordships to section 104, my lord, which is on page 76
Of the new act.
of the new act. Yeah, no, page 76, yeah. I will, it's all right.
Red four.
Now, my lord, your lordships will see the title is Application of Act to Properties Given or Donated by Persons Not Professing Islam for the Support of Certain Waqf. Now, kindly see, my lord, the original act that your lordships will see on the next page in a footnote. It, my lord. Notwithstanding anything contained in this act, where any movable or immovable property has been given or donated by any person not professing Islam for the support of a waqf being a mosque, idgah, imambada, dargah, khanqa, maqbara, Muslim graveyard, choultry or muzaffar, then such property shall be deemed to be comprised in that waqf and be dealt with in the same manner as to the waqf, as the waqf in which it is composed. I'll make a point on this in a moment, my lord. Then can you turn to section 23, my lord? Lord, now, if your lordships will see that it says there shall be a full-time chief executive officer of the board to be appointed by the state government who shall be not below the rank of so-and-so. Now, my lord, kindly see the original section. If at the bottom of that page, my lord, there shall be a full-time chief executive officer of the board who shall be a Muslim. I won't read the rest, my lord. There are at least 12 sections of this act which deal with the powers, duties, and responsibilities of the chief executive officer. And I'll make one or 2 points, my lord. Now, my lord, kindly come to section 2. This your lordships will find on page 5. See that a proviso has been added. Provided further that nothing in this act shall, notwithstanding any judgment, decree, or order of any court, retrospective, apply to a trust by whatever name called, established before or after the commencement of this act, or statutorily regulated by any statutory provision pertaining to public charities by a Muslim for a purpose similar to a waqf under the law for the time being in force. My lord, I won't elaborate other than judgment after judgment of your lordships, my lord, have indicated that a waqf can be in the form of a trust. Earlier, my lord, the board decided whether it was to be a trust or whether it was to be a waqf. Now, this was a very important provision, my lord, right from Ratilal, the first decisions of your lordship, 7-judge bench. There has never been any doubt that if your objectives were in the form of a trust, similar, and those are the words used here, my lord, similar to those of a waqf, this will entirely and completely disappear. Now I will make, my lord, two very general points.
I didn't get you.
My lord, earlier, supposing I am a waqif, my lord, and I create a trust which has objects similar to that of a waqf, it would be in the past treated as a waqf. Now, my lord, many, my lord, waqifs put their objectives, ultimately, remember, my lord, it's the object of charity, object of religion. Now, if the object of the trust is similar to that of a waqf, and there were a large number of them across the board, my lord. Ratilal, my lord, is a case from Bombay. It dealt with the charity commissioners, and the issue once there was whether the charity commissioners would have control or whether the waqf board would. And your lordships ruled that if it is similar to a waqf, then, my lord, it is not the charity commissioners who will appoint, my lord, the custodian.
But the board.
The board. Or the board as it then stood, my lord. Now, this is an important takeaway, my lord, because a large number of waqfs are in the form of a trust. What this does is, what was earlier a matter of form has now been removed as a matter of substance. Just 3 points on that, my lord, and 2 additional points I want to make.
What you are trying to say is basically that any trust would not be a waqf anymore.
That's right, my lord. Even if it is similar, my lord, trusts are in their own area.
That's right.
There is a distinction between the two.
Yes.
But if it is similar to the nature of a waqf, it would be treated as a waqf.
Correct.
And there are a large number of such throughout India. Now, my lord, I have 2 more points to make, my lord. My lord, Mr. Sibal has already indicated, and this has never happened, my lord, in the past, of the redefinition of a religion and religious property. Never before, my lord. We go back to the Board of Revenue of 1810, my lord, of the East India Company. They didn't change the nature of the waqf property. Neither 1817 in Madras, nor in the 1923 Act, my lord, nor in the 1994 Act, nor in the 1995. What was the occasion, my lord, for this large-scale liquidation of the very concept of waqf? My lord, no religion in the world can survive apart from belief, practice, property. You take that away and no religion will have any longevity at all. So this goes to the heart of every religion, and it is only the Muslim religion where this property has been dealt with in this way. But that is not my only point, my lord. The important point is, my lord, it's an issue not just, my lord, as far as this is concerned. My lord, we are a secular nation. One of my clients, my lord, in the writ petitions not listed before your lordships, happens to be a Sikh. He says, I want to contribute to waqf. I believe that this property should not be taken away. This is an issue which goes fundamentally to the question of secularism, Lord. Because Article 25 and 26, and I would add Article 29, the preservation of one's culture. That's right.
Article?
Lord, 29 as well, which is the right to preserve your culture. How would you preserve it, my lord? Preserve it on the basis of your beliefs. You preserve it on the basis of your practices and on the basis of the property that sustains these beliefs and practices. Take that away, my lord, the entire secular edifice which your lordships, my lord, have built from time to time and time again, my lord, will also become suspect. One last point, my lord. Mr. Sibal has dealt with, my lord, classification, manifest arbitrariness. My lord, when you justify these changes, what is your justification? What your lordships, my lord, have laid down is the doctrine of proportionality. Where is the proportionality? Now, they, on the other hand, says there is better effective management. At one stage in the counter, they say certain persons were not registering as Waqf by user. So, my lord, the question that your lordship might put to them is, you want to achieve certain goals. It has to have a nexus that's established. Where is the proportionality behind the changes that you are now making in relation to the objectives to be achieved? And my lord, across the board, no justification has been given as far as proportionality is concerned. My lord, I adopt the rest of the arguments.
So pleasure hearing you after a long time.
I know, my lord. Even in my throaty voice. My lord, there's one small point, my lord. This act is in the teeth of a large number of constitution bench decisions of your lordship. Charity, Ratilal, Babri Masjid, my lord, para 1131, which says Waqf by user is a part of Islam. So it's in the teeth of a number of constitutional. Now, my lord, your lordship interpreted in TMA Pi the meaning of the word establish and administer.
It's 1134 paragraph.
1134. That is in M. Sadiq, my lord, the Babri Masjid case.
2021 SCC, page 1.
So, my lord, now, my lord, the question as to whether educational establishments also came in TMA Pi, in para 25 and 26 of TMA Pi. The phrase is establish and administer. I have a right to establish, my lord, under 26B of the Constitution. I have a right to administer. Those rights, it is stated way back in 1954, no legislature can ever take them away. That's all. I'm very deeply obliged.
Please, so I will finish even before possibly the end. Very pointed.
Bear down your.
It's difficult to navigate what is left over, and I'll try to just give you lots of points without repeating.
Let's all shift.
Incidentally, well, it's the first learned judge who could be heard holding his own court in Supreme Court and other courts came from my state. And the second learned judge, there were two learned judges, Malas, who could be heard in other courts.
Yes.
One from Rajasthan in the old days, and then one from Mumbai. Justice Tulsapurkar, Justice Bhargav, who was the uncle of Justice Suresh Agarwal. They are the two learned judges you could clearly hear them in those days. Anyway, now, Malas, the first point, and I'll make it only point formulas. 3R, your lordship has seen. Just pick up 3 small r for a second. Now, 2 points have already been made in the text of it. Your lordship's page 7 of the Act, perhaps. The 2 elements there are, one, proof of your practicing Islam. And the second is this delightful word, contrivance. First thing is, brothers, that you can never apply, look at the word, brothers, and that there is no contrivance involved. It's a recipe for making the applicant visit the offices of the collector or the officer for eternity, trying to prove that there is no contrivance involved. It's the most vaguest, arbitrary, completely whimsical word used to invite terror, control, and endless visits to the government office. Second, Well, it's people of all religions make religious endowments. All. And India is, well, as planet Earth's most diverse spot. Which other religion, at the point of making a religious endowment, by whatever name called, is asked for proof of that religion's, well, as professing and practicing? For 1 year, forget 5 years. For 5 years, for 10 years. Which religion? Point number 2. Point number 3. That brings in directly an article not really directly mentioned, Article 15. This provision goes on the short ground subject to my Lord's discretion of violating Article 15. Textually, it is a discrimination on ground of religion. And its donors and its creators of religious endowments are asked for proof of their religion, which is directly contrary to Article 15, which Lordship knows very well, Willis. Out of 7 or 6 tests, the first word is religion in 15.1. The state shall not discriminate against any citizen on grounds only of religion, comma, and this is only religious, race, caste, sex, place of birth, or any of them. Religion is the first. And it is singular, Willis, in its novelty. The state is discriminating by using parliament to pass a law, and therefore that law is unconstitutional. Well, my second point relates to the Waqf by user point and goes slightly beyond. It has already been made. I only want to fill up a gap on this. By its very nature, Waqf by users were largely unregistered. At some point of time, a requirement came to give particulars and register, be there aside for a minute. Whereas the subpoint in 3C and all the other provisions there is the access to court point, the remedialist point. Now, my learned friend has already shown to your lordships the arc which connects 3C, 36.7, 36.7a, and 36.10. That must be kept in mind. And well, it's a vicious circle that once you cease to be Waqf, you cannot exercise the remedy, principally because you're not a Waqf. So it's trying to catch your tail. The ground.
But please repeat yourself.
This arc is very interesting. Just let us pick up 36. 3C, my lord, has seen dispute. The counterpart of 3C is found in 36.7a. My lord has noted that there also a dispute means you're not a Waqf. So one principle is in this act. The moment there is a dispute, a Waqf, so-called a Waqf established, a Waqf 500 years old, ceases to be a Waqf.
That's what.
Both 3C and 36.7a.
That's what Mr. Sibal also.
Yes, but I'm not on that. I'm now on the access to justice. Now, the moment you cease to be a Waqf, there is no question of registration or unregistered Waqf moving a court. And the bar of 36.10 applies in full force. That's why my Lord Bernard read your worship 36.10. So I say it makes a vicious circle that any dispute, and the dispute can start tomorrow. It doesn't have to be a pre-existing dispute. It doesn't have to be a dispute leading to a decree or an appellate decree or a Supreme Court decree or prior to this date. It can be a dispute started tomorrow. I can start a dispute tomorrow with this. It's clearly exclusionary. Now, what I'm going is one step further. I heard an interruption saying the 36.10 was always there. That is more than a half truth. Please note what was the 36.10 predecessor. Give this note. Come on, quickly. This is not a note for reading, it's just for the quotation I've given you, so it'll be easier. Please ignore all the text. I'm not giving it to the side.
Note at the end. I know you just
can I read a provision of statute from a note?
Yes. Not note.
Mr. Mehta, I hope that's not your best point, Mr. Mehta.
No, that's not.
Now, let us come to page. Kindly come to page 4. Till now, I have not read the note, brother. I'm in terror. I'm reading only the provision from the note. Para 7. Now, this is important. Well, let's just don't read it for a minute. Give me a minute, please. In the 1984 Act, there was a bar of initiation of proceedings.
You are reading paragraph?
Well, it's 7 at page 4 of this note. Just the quotation I'm using it for. Does my Lord have it? My Lord. See the underlined portion. Unless such waqf has been registered. Right, brothers? Now your Lordship will note the next line. The amendment was not brought into effect is an admission and a fair statement by Mr. Mehta at page 36 of his counter, para 55. That italicized statement by me is a quotation from Mr. Mehta's counter, page 36, para 55. I hope I'm clear, Melissa. So a broad ouster clause was never brought into effect according to the counter. Now, the next provision quoted is a provision in the 95 Act called Section 87. I hope there's a misprint there, that section should be 87. If there's a misprint,
That is correct.
corrected. I'm grateful. Now, this is another, the wordings are not identical. We are not concerned with that. Again, another kind of ouster. See the underlined portion, unless such waqf has been registered. Right, fellas? This was deleted by the 2013 amendment. That's why I said it's more than a half truth, fellas. From 2013, this deletion stands. This vicious circle of connecting 3C, 36.7, 36.7a, and 36.10 starts only with this 2025 regime. I hope I'm clear on my second point. My third point about that ancient monuments, where Mr. Ahmadi has made a very comprehensive note, which I will not go into. Just
This side will have to conclude by 4 o'clock.
I will conclude in
We have already granted more than.
I have started at 3:35. I'll conclude.
No, we don't know.
Well, before that, I'll conclude.
Well, we had said 2 hours, but we are again, if we continue till 4 o'clock, we will be giving more than 3.5 hours.
I will conclude, my Lordship may not doubt that at all. 100%. Even if I don't conclude, I shall conclude.
The others are in waiting. So
Yes.
everybody would like to.
Now, let me just say what I wanted to say on this, just for a minute. On 3D,
If something is left.
No,
I'll try and leave it.
no, not more than 4.
Let's finish. Let's use the time we have.
Yes. Since 20 minutes are left, we thought that Dr. Singh would be generous for others.
My lord, 4 minutes for me, my lord, because I have.
This will take away my 20 minutes. So let me finish as soon as I can.
After that, my lord, finish. My lord, should consider that.
Now, the 3D, number 1, 3D, all the other facets of 3D are not repeating. That has been argued. 3 capital D. It would, read as it is being read by the government, would even circumvent and impinge upon the Place of Worship Act, 1992. Your Lordship reading it differently is something else. I'm not concerned about how Lordship read that, of course, can be protected. Lordships can read it. As textually framed and as argued, this non-obstant situation in 3D, superimposing Ancient Act, Monuments Act onto this, superimposing 2025 Act on the Ancient Monuments Act, has a direct result of affecting even those protected by another special act called the Place of Worship Act 92. Effect of the Places of Worship Act 1991. I'm sorry, 1. Because something, let us say, a character of a place of worship, which is X religion, Y religion, Z religion, is shut off on a cutoff date. Today, by a notification here, for example, for Muslim places of worship, you will create a situation where at least the Lordship will have to work it out. Otherwise, on a literal interpretation, it will override that. The second point on that, brothers, is
Work out what? work out what? You said that we'll have to work out.
No, your lordship, unless absent your lordship's interpretation that the Place of Worship Act protection or cutoff date remains a Muslim place of worship, a place of worship.
Ancient monuments.
Well, I am arguing Place of Worship Act. I am not arguing ancient monument. I am saying if you notify under the Ancient Monuments Act.
According to him, by superimposing
Yes.
the Ancient Monuments Act on the by 2005.
And the declaration under
Act
D.
also affects the rights available to the citizens under the Right to Worship Act 1991.
It's not even an argument to be dealt. I'll deal with
It
it.
is my argument, not your argument, because you haven't.
But it is a pleading.
Yes, yes.
It is a pleading. It is a pleading. We'll give that also. Take it out. It is a pleading.
In fact, ancient
Because
act overrides all other laws.
a Malak's monument, which is a monument which is protected under the Place of Worship Act, can be declared under a notification under 3D. That is the point I'm making.
3D, there is no notification.
3D opens the word notification, allow me to have my 15-20 minutes, let me have my fundamental right to say wrong things.
15-20 minutes.
No,
You decide about yours.
he is not allowing me my fundamental right to say wrong things, Your Lordship. What do I do?
Then
He is interrupting me every sentence.
we don't mind, but then we will not be
No,
careful after
I'm
that.
trying to finish. The next point here is Article 15 comes in again. Because on 3D, Your Lordship has chosen one religion in this act. Not Your Lordship, the act has chosen. One religion.
This act itself is applicable to one religion.
That's right. Now this particular,
Choosing one.
this act applying this interpretation of the Ancient Monuments Act to one religion is what hits Article 15. That's my point. The fact that 3D textually applies the Monuments Act on this act and this act on the Monuments Act is only for one religion. That's Article 15, Manas. Your Lordship is considering prima facie constitutionality and whether to give Manas some interim orders. Therefore, this is very relevant. Now, Manas, this is as far as 3R and 3D is concerned. Lordship may also note that Your Lordship knows the law very well, that Your Lordship doesn't normally grant a stay. But look at the language Your Lordship used in the Farm Acts case, Manas. Kindly hand over that case. Bernard, give that case. Rakesh, give it quickly. Manas, 2021, 1 SCC 590. Rakesh Vaishnav, about Manas, giving us, we are not asking for a stay on the whole act. We are talking of the provision Lordship has heard us on. All these provisions. My Lord has said this about the whole act. Kindly hand it over.
This was an unopposed order. We conceded. Let us you be clear and honest about it. Justice Bobde's order, Madam.
I can't be clear and honest about anything before opening the book and reading the case. Kindly turn to us. Para, give me that book. Give me this one. Yeah, wait, you don't. Give me that. Just give me 1 second, brothers. Para 10, 11, and 14. If my Lord comes to 10, let us see what the Attorney General said, and let us see that the last interruption of Mr. Mehta was right or wrong. Please turn to para 9. Para 9. It starts at when we put across above suggestions. Got it, brothers? Your Lordship got that? Para 9 starts like that. The learned Attorney General, even while agreeing for the Constitutional Committee, vehemently opposed the grant of any stay of the implementation of farm laws. I don't know what that English language means for us. Next page, continuation para. The learned Attorney General contended that the court should not stay the implementation of the laws. Therefore, para 10. The aforesaid submission of the learned Attorney General, this court cannot be said to be completely powerless to grant a stay of any executive action under statutory enactment. Even very recently, Jayashree Lakshman Rao Patil. Now come to 14. I agree with this. Your Lordship doesn't grant it for the asking. But if there is one act, one statute, one case, which cries out for certain absolutely sinister provisions requiring to be said, this is it. Having heard the different perspectives, we deem it fit to pass the following interim order with the hope and expected both parties will take the right spirit attempt to arrive at a fair, equitable, just solution. The implementation of the 3 farm laws, all the laws are listed, last line, shall stand stayed until further orders. As a consequence, the minimum support price in existence before the act shall be maintained. We are asking for much lesser ones. We are asking for much lesser. Then, Malas, your Lordship's recent judgment on 300A, authored by Justice Gawai, Chief Justice Gawai Malas, just a few weeks ago. I'm not saying that Malas is all, just note the citation. 300A.
That Karnataka matter?
Yes, Malas. Called Malas Bernard Vaz. 2025 SCC Online SC20. Don't read it, just bear with me, Malas. Kindly note the citation. Court master will do it. Paras are 42, 43, and 56. The important point is that your Lordships could have decided on the Karnataka statute about delayed compensation. My Lords made it a point in para 42, 43, and 56 to say that what must imbue your Lordship's interpretive approach must be 300 capital A. Namely, how you will interpret a provision, what will be the effect of that interpretation if it is expropriatory, and we have shown in detail what is expropriatory. I don't have time to repeat that. It will be imbued by what your Lordship calls in those paras 42, 43, and 56. It's not a mere statutory right. It's a constitutional right. It may not be a fundamental right, but it's much higher than a statutory right. That's what your Lordship says. So kindly note these 3 paras, 42, 43, and 56. Okay. Your Lordship has got this thing about increase of trust by 100%, etc. properties. Just note this, Malas.
42, 43, and
56. Where is that note? Malas, it is said, one of the arguments in the counter is that there is a huge surge in Waqf properties. Suddenly, a huge surge, explosion in numbers. Just note the answers, A, B, C, D. A, the loading on a portal which they've created for listing Waqfs started in 2013. The loading onto the portal. That is pointed out in my rejoinder at page 5. Lordship may just note it for saving time. Therefore, as the portal was populated over time, the numbers had to increase. Before that, you had no population on that portal. They are treating an increase in the portal population of listing as an increase in Waqfs. An updation exercise. Number 2, the learned Minister of Minority Affairs on 18th of July 2019 at the rejoinder page 60 of Mr. Ayubi's file. Mr. Ayubi's writ at page 60 has the answer to an unstarred question. He says we have increased now and are proceeding day to day on increasing digitization. So what is being prejudicially suggested to your Lordships to increase numbers of Waqfs is actually an increase in the portalization and the digitization. Thirdly, there are many properties in a Waqf area sometimes. They were treated as one Waqf property. Now each is listed separately. This is all stated in my rejoinder. So let us not have these prejudicial arguments in the counter that there is an again and again a lot of prejudicial arguments are given. That you must have more and more, you are having an explosion. Your Lordship should be aware in this note. Just turn to one fact. All we are talking in the abstract about registration and non-registration. In this note at page 2, extract from the JPC. Just see this for a minute, the note I gave. We are talking in the abstract about registration, non-registered, work by user, etc., etc. 2 figures only the Lordship will note. This extract at page 2, 2 minutes more, 3 minutes more. For the state of Bihar, the Bihar Waqf Board filed a document before the JPC. It's only extract from there. It is an annexure to the JPC, it's extract from there. Out of 20,000 mosques, only 5.98% are registered. Just note that one line. And
Not.
second page, which is an extract.
Anyway,
And the second line is, on 27,000 graveyards, 3.6% are registered. This is from the Bihar Waqf Board's written submission and annexure to the JPC report. And well, let's note my learned friend's counter with annexure at 195. Where is Mr. Mehta's? Page 195, PDF page 197, please.
Zero.
He says 50% roughly are worked by user. The figure he gives is 8.72 lakh properties, of which 4.02 are worked by user. Only that one line also saved time. His own counter, annexing one as part of the JPC extracts, says that. But there are some more things, but I'll give it a note of necessary. There's one last thing, and I'm generally. But it's just these pages, references, Lord should be known because I don't have time to see it. The reference I gave last was about the 195 of the counter, where the annexure is given, which says out of 8 lakh, 50% are worked by user. There's two more statistics and I'm done. Para 80 of Mr. Mehta's counter. Para 80. Para 80 of his counter says those works which have not been registered nor have they been found in existence during the survey by the Survey Commission, their claims are not maintainable at this belated stage. This is para 80 of his counter. The emphasis of the word survey by the Survey Commission. Well, as your Lordship will note, the JPC report at page 92 points out that survey is done only in 5 out of 28 states. It's a travesty. Just note the reference, page 92 of the JPC report. My friend's counter doesn't point this out. 5 out of 28 states and 4 out of 8 UTs.
New facts.
This covers JPC.
Just filed a note with new facts.
I have not filed a single note. I am quoting from your counter. Now let us go. I have quoted from your counter and the JPC report. Please don't misrepresent. Please don't misrepresent. Now, 9.3% of the area of the country as a whole is what these 5 states and 4 UTs represent. You do a survey in 9.3% of the area. In your counter, you say that in our survey, we found no registered bucks.
Not survey.
Your survey is only in 5 out of 28 states. And then you try to shut me out. I'm deeply obliged.
May I just take two? I'd like to take 2 minutes. Just there's one aspect which your lordships.
I won't get a turn.
But your lordships were there's a point where there was some concern expressed by the court.
We don't detain you any time. We are not detaining you on a single day.
I have to see you a lot.
We quite appreciate your difficulty. You have to be at the right time before the other court.
Today, your lordships can't say that. Today,
But
lordships can't say that.
Lord, I just want to answer one aspect because your lord, several questions fell from my lords when my learned friend Mr. Sibal and Mr. Dr. Singh were arguing, was with regard to the mandatory registration requirement. So I just want to place the correct position with regard to that. Plus, there's a 1923 Musalman Waqf Act, 1923. Is the first time, it's not registration, the first time a requirement came for declaration. Under Section 3, a declaration was to be made to courts with regard to Waqf, and Section 5 required some accounts to be maintained. In that act, the responsibility was of the Mutawalli, and under Section 10 of that act, the penalty, Section 10 of the 1923 Act, my lord may just note, the penalty was 1,500 rupees, and for repeat offences, repeat subsequent offences, 2,000 rupees was the penalty. There's Section 10 of the 1923 Act. Section 3 is the obligation to furnish information by making a declaration to a court. Section 10, penalty on the Mutawalli was 500 rupees for the first offense, first conviction, and 2,000 rupees for all subsequent convictions under Section 10. Then comes the 1954 Act,
which is the first post-constitutional act, which is the Waqf Act 1954. Chapter 4 provides for registration of Waqfs by the Mutawallis. Section 41 of the 1954 Act provides for a penalty of rupees 1,000 for the first conviction for non-registration, and for subsequent convictions, if there is a subsequent conviction, the removal of the Mutawalli under Section 43. The Waqf doesn't go, the Mutawalli goes under that provision. Then comes the 1995 Act. And in the 1995 Act...
What is the provision in the 54 or 58 Act?
In the 1954 Act, Chapter 4 provides for registration of every Waqf by the Mutawalli. It's Section 25 onwards. Section 41 provides for penalty of rupees 1,000 for the first conviction. And under Section 43, if he is convicted a second time, the Mutawalli suffers removal without his rights as a beneficiary going, but as Mutawalli, he gets removed from the Waqf. That's the only consequence. Now, my lords, comes the 1995 Act, which is the present Act. 2025 is an amendment. Now, Section 36 in Chapter 5 provides for registration of Waqf from 1995 till today, till 2025. And Section 61 provides for penalties. The penalty in Section 61 for A to D, A is registration. The penalty for a violation of A to D is a fine of rupees 10,000. And for E, F, G, H, which are most grievous things, which don't have to do with registration, but with taking away properties, etc., is imprisonment for 6 months. Now, even today, even in the 2025 amendment, the penalty for non-registration has been just increased to 25,000 rupees on the Mutawalli. Non-registration does not carry any other consequence except a penalty on the Mutawalli. Even in the 2025, it's only a 25,000 rupee fine, which is imposed on him. So now, please see the definition of beneficiary in 2A. My lord may just note it. This is a very unique situation right from the 1954 Act. The exact same definition of beneficiary is there. And in Waqfs alone, unlike other trusts, not just the people who benefit from it, but the objects are a beneficiary. So if my lord just sees the definition of beneficiary, and from 1954, 1995 and 2025, beneficiary means a person or object for whose benefit a Waqf is created and includes religious, pious and charitable objects and any other objects of public utility sanctioned by the Muslim law. The same definition, 1954, 1995, 2025. So the beneficiaries can't be made to suffer for the offense committed by a Mutawalli. That is the whole point. The objects of the Waqf don't disappear. Because if the Mutawalli has not gone and registered, or suppose there's some impediment on registration, he was not able to find the records, etc., or for whatever reason it's not registered, neither the objects can go, nor can the beneficiaries who are the who benefit from it, can be deprived of that. And that is why, my lords, no law, including 2025, has a consequence of Waqf vanishing. Now, 2025, by the other provisions in 3C read with 36, 7A and 10.
7, 8 and 10.
Yes, there the entire Waqf vanishes due to non-registration. That is why it's very, very egregious.
Can I start tomorrow at
Lordship, just hear him for 5 minutes. Just 5 minutes.
Now notes can
We had requested all of you to share your time with him.
No, just one thing. Our note, the spiral bound note, we had, as your lordship director, we had shared our points with Mr. Singhvi.
You give a consolidated.
No, that is a consolidated note. So your lordship, read that note as our submissions.
This is spiral one is the consolidated note.
You please read that as our submission.
My submission is the
Yes,
consolidated
It contains submissions of everyone.
Yes, I have incorporated.
In vacation, we don't want to just
it's not there. I didn't argue those proportionality, all
But that may be read.
Commercially, Dr. Singhvi argued.
It's all in the notes, mother.
consolidated note. Mr. Singh's note contains everyone's argument.
Mr. Izaz has prepared it.
to saying that.
You are prepared.
Yes.
But my points are in that note, Your Lordship may
Just
kindly.
let him say a few words at least.
Let Mr. Ahmadi, my lord, give
Just a
him
few words,
2-3 minutes.
Okay, we'll wait. Okay, give 5 more minutes. Yes.
That's all.
I leave it to your lordship, Mullah. I wanted to assist your lordship. If your lordship feels, Mullah, that
We know that you all of you are prepared, but
I don't want to say anything.
no, therefore we had requested Mr. Sibal the other day that please,
Yes.
your time is we will also not give more than tomorrow to the other side also.
Very
That they have to,
Exceed, 2 hours is,
whatever time you have given it to them, we'll give it to you.
I'm not followed on that.
Ordinarily in the opening,
They have
Mullah's council takes a
Crossed
little longer.
much
to be
beyond
able
2
to-
hours.
On an interim
Because
meeting.
some facts are to be stated.
Yes.
Now, just very quickly, Mullah.
Yes, please.
May I just very quickly state a few points, Mullah? I have prepared a separate note.
No separate.
Separate.
Otherwise, you take this note back and give us a
No,
consultation.
very well. Then I will not go through that. Mullah, just 2 aspects that I want to highlight. Just, Mullah, have the act. If your lordship just has section 108 and section 107. The impact on evacuee properties is quite substantial. Now, 108 was already read to your lordship.
Dr.
Yeah.
Dhawan read it.
Yes, ma'am. Now kindly see 107. Does your lordship have 107?
Yes.
On and from the commencement of the Waqf Amendment Act 2005, the Limitation Act 1963 shall apply to any proceedings in relation to any claim or interest pertaining to immovable property comprised in a Waqf. Coalesce it with section 108, which deletes evacuee property. Now, the effect of 107 and 108 together is that evacuee properties are out by virtue of section 108. So therefore, a registered Waqf in relation to evacuee properties by virtue of deletion to section 108 gets obliterated. Now today, my lords, by virtue of section 107, if I want to challenge any such declaration of evacuee property per se, that will be hit by limitation.
That will be hit by?
Limitation, because the Limitation Act applies. So those declarations, my lords, which are age-old, which were protected by virtue of section 108, that those works existed by virtue of section 108, because the number of evacuee properties which are declared as works are huge in number. Point number 1. Because for paucity of time, I am not elaborating those points. Point number 1. Point number 2, my lords. So far as section 3D is concerned, 3 capital D. Plus, I won't read 3D again, but your lordship recollects the text of 3D. What 3D says is that any property which is declared as an ancient monument either under the Act of 1904 or under the Act of 1958, that declaration shall be void. Now, Marot, just contextually, the history has been explained. The Act of 1904 and the Act of 1958 has listed several properties, including, my lords, ancient mosques. Now, at the time, my lords, of the 54 Act, 23 Act, my lords, only applied, my lords, in respect of declarations. So under the 23 Act, all that you have to do is seek a declaration before the court. That's for the first time that the provision for declaration came. The 54 Act for the first time, my lords, made registrations compulsory because it says it shall be shall. Now, even if I have a registered Waqf, under the 54 Act which I have registered, under the 1995 Act registered of any nature, whether it is Waqf by user or otherwise, all of them get obliterated if on the date of the registration prior thereto, this was declared, my lords, as an ancient monument. So ipso facto, my lords, A, it is retrospective. And second is, my lords, by virtually by the sleight of a hand, my entire works, all of them which were registered earlier, my lords, completely gets obliterated by the operation, my lords, of section 3D.
Now, the reason why, my lords, the argument, the submission, my lords, on Article 15 is extremely important is that there is no similar or analogous provision in any other act with relate to any other relation.
That is what Atta Singhi also argued.
Correct.
Article 15.
That's correct. So, my lords, this only singles out one particular community. And, my lords, that also happens to 3E, because insofar as tribals, scheduled tribes are concerned, even, my lords, the very same provision, my lords, applies. So that's, my lords, the additional point that I wanted to make. The third aspect, my lords, of this particular of 3D is your lordships, my lords, under an interim order have restrained any further suits which are impinged upon by the Places of Worship Act of 1992. Now, the effect of 3D is that even those ancient monuments, my lords, which are protected specifically by your lordships interim order, will all get resurrected, because the government today can say that so far as those particular places of worship are concerned, I will regulate the manner in which the practices are to take place. So today you may say you will not use it for any purpose whatsoever. By virtue of 3D, that is the effect of 3D. So that therefore, my lords, that's an overarching provision. Fourth point, my lords, just very briefly I'll make it. I made my point on evacuee property. I made my point on limitation. Just one more aspect, my lords. The expression practice of Islam for a period of 5 years. And, my lords, that aspect of contrivance.
5 years.
5 years. Now, my lords, firstly, the point has been made that, my lords, in any other endowment act today, if I want to endow a property for the purposes of for a temple, there is no restriction, my lords, that I have to prove that I am practicing that particular religion for a period of 1 year. That's point number one. The second aspect, my lords, is how will you determine this factually? Is there an ascertainable principle by which you can determine this aspect as to whether this person is a follower of Islam or not? For example, my lords, can someone ask me that do you pray namaz 5 times a day? Otherwise, I will not permit you to make an endowment. That's an essential feature of Islam. Suppose some other Muslim is asked, do you drink? Will that be a criteria, my lords, for the purposes of saying that don't have it? And so far as contrivance is concerned, my lords, suppose tomorrow, my lords, someone wants to make a particular endowment. How will you determine, my lords, whether that is contrived or that is not contrived? That's the third aspect. And lastly, my lords, what I want to say is that so far as government properties are concerned, comes into force merely, my lords, upon a dispute being raised. There is no real formal adjudication which is required for this particular purpose.
That is already elaborately.
So therefore, my lords, therefore, my lords, in sum, all that I'm saying is that so far as my lords 3D is concerned, its impact is drastic. My lords, it will apply to age-old mosques, age-old properties, and 3D, my lords, really requires an absolute stay in my respectful service.
I appear in the 5th of the 5 lead matters.
Thank you.
Only 4 have been. Lordship, I just have two points to make. That's all, Lordship. Not detailed submissions. 2 points which have not been made so far. Lordship, the first is.
Everybody says that, but then.
Lordship, and I'll keep my word, Lordship.
Lord, it's almost 3.5 hours. I'm not objecting, Lord.
No, 3 hours, 45 minutes.
Lordship, it's already been stated.
I have come from Srinagar, my lord, only for this matter because most of the property of Waqf property is there in Srinagar. Please give me.
Lordship,
you include your points in the
classification is listed.
Lordship, it has already been.
2 minutes, I will make question clear as far as Waqf
Please.
How much time your side? How many? Who are going
We
to
are
argue?
5, but I'll start, my lord, and I'll cover, my lord, substantially, but we'll not take more than what they've taken. We can.
You can't.
assure you.
You should take lesser than that.
Yes, certainly.
So that we should give them some time
The
for
points
review.
which were not brought to your lordship's notice, my lord, half sections, etc. But I'll have to show, my lord, what is
Lordship,
the
I'll
real
just take a minute.
purpose, intent, object.
Lordship,
That's a very important point. So,
please.
I'm better. Better than his.
There is a Waqf board also.
इसलिए नहीं हाँ, तो ये तो part है, इसलिए नहीं है ना
Well, interestingly, one of the state Waqf board is before your lordship supporting this. We'll point out, my lord, I'll point out.
Lordship, in a very quick minute, Lordship. Lordship, it's already been said that
That's the only good.
My lords may grant us tomorrow, my lord, because
No, sorry.
my lord, there are good, my lord, important points which I have taken in
Lordship, mine
application.
is the fifth matter out of the least
Just
matter.
3 minutes, my lord. I will not
Four
take
have been
more than 3 minutes.
We had requested
My
all of
lord,
you
on the religious
to
point,
time in 2 hours.
in the
We have
context,
given you almost twice of that.
Lord,
we
in
have
the
no
context of
we have
religious,
no
if your
control
lordship
over that, Lordship.
would consider my application, everything has been detailed, my lord, everything has been spelled out in time.
Lordship,
Lordship may kindly give us tomorrow, my lord, 5 minutes.
Please don't do this.
Lordship, 5 minutes, my lord.
So you give your notes.
Lordship, I appear in one of the lead matters which have already been selected as a matter that have to be heard. Lordship, I'll just take
We
2
had
minutes.
requested you to fix up timings among yourself.
Lordship,
Instead of
that's
2 hours, we have already granted you 3 hours 45 minutes.
Lordship, as the youngest member of the family, that's not something I control, Lordship. So I'm just asking for 2 minutes of my Lord and to make points which have not been made so
Okay,
far.
2 minutes by the clock.
My lord, 2
Very well.
minutes for me also.
Please.
Okay.
I shall be grateful.
Okay, come. Atrocity department.
Correct.
Being a heritage structure. Still the people can go and pray.
Exactly. So, Malas, now the 2025 Act says, moment it's declared or it has been declared as an ancient modern community, complete takeover, including ownership, before or after.
No, but does it take away your right to practice your religious practices?
Yes. I will demonstrate to the declaration itself is void.
Are you stopped from going and praying there?
Yes, declaration of the Waqf is void. It's not about whether it is void.
Should we record that?
Yes, that's the third proposition.
Fourth.
Yeah.
Sorry, third.
Yeah.
On such declaration.
Yes.
As a,
On or before,
on such declaration as an ancient monument.
yes, as a protected monument
But
or protected area under the
for last 6 years too. But then
No, it says Ancient Monuments Preservation Act 1904.
so on such
Ancient
declaration
monuments,
as a protected monument.
yes. Or protected area.
Protected area.
Under the Ancient Monuments Preservation Act and Ancient Monuments and Archaeological Sites Act of 1958, at the time of such declaration.
Under the State Act.
Yes. Yeah, and Waqf property shall be void.
No, but does it also take away your right to go and practice
Once
religious
the
practice?
Waqf is void, Mullah, I can't go there. The Waqf itself, it becomes void. That's what the section says. Any declaration or notification issued under this act or under any previous act in respect of Waqf property shall be void if such property is as a protected monument or protected area. So once it is void, Mullah, how can I possibly go and...
Like, Kajura, I know because I had visited recently. Call now under the custody of archaeology department because all those structures are heritage structures. But still there is a temple wherein all devotees can go and pray.
Yes.
So therefore, I'm asking whether this declaration would also take away your right of going there and praying, offering prayers and all that.
Well, the problem is...
Maybe because it will be declared cease to be work because the maintenance and everything of a heritage structure is on a different yardsticks.
But if the Waqf is void itself, that means it's no longer a Waqf. Then it's not my right anymore, Mullah. When you say Waqf is void, it's no longer a Waqf.
But is it your also contention that on such declaration, all religious practices which were being undertaken earlier would also not be permitted?
Mullah, it's my case that this provision is violative of 25, Article 25 of the Constitution.
Should we record that?
Yes, please. It's
What will
expropriatory.
be void
Yes.
and the right of the citizens
Yes.
to continue with their religious practices.
That's correct. Article 25 and 26.
Their religious practices.
Can
Will be taken away.
taken away. Therefore, it is expropriatory.
Mr. Mehta, you can ask someone to record all this.
But I am recording it. It's factually incorrect in my.
We are not asking you, we are not
I'm
asking.
recording. I'm recording.
You argue when your turn comes.
Yes, I'll argue when my turn comes. I'm recording.
We are only asking because since we are recording, we'll be calling upon you to answer this thing.
Obviously, I'll have to answer.
The rights of the citizens to continue their religious practices will be stopped and therefore violation of 25 and 26. So what we are recorded on such declaration under the Ancient Monument Preservation Act as a protected area. The work
Monument or area.
the work will be void.
Yes.
And the right of the citizens to continue with their religious practices will be jeopardized and therefore violative of Article 25.
25, 26 and 14, Malat, because how do you declare something to be void, because the perpetuity of the dedication is lost.
Article 14, 25 and 26.
Yes, I'm good.
Yes.
Because only Muslims are there.
Yes, sir, I know, only Muslims, of course.
So
Don't want.
you should have invited all of them for dinner yesterday and so that it would have been better. Now everybody is advising you here.
I forgot.
Well, that's the other important thing that your lordships will know, this is a corollary to this proposition, is that under the Ancient Monuments Act and these two acts, my right to religious worship was preserved.
So that
Despite its declaration. Under the acts themselves, it was preserved.
and now it is being taken away.
And now it is taken away.
Under the said act,
No, it was preserved.
right to religious practices preserved.
Yes.
Yes.
Right? I mean, it says that a protected monument maintained by the central government under this act, which is a place of worship or shrine, shall not be used for any purpose inconsistent with its character. It was preserved, taken away.
16.
That's 3D, Malaj.
6.
Sorry, 1 second.
Section 3D.
This is the present 2025 section is 3D. D, capital D. Next proposition, Malaj. That I have to be a Next proposition, Malaj. That I have to be a practicing Muslim for 5 years before I can create a waqf. So, Malaj, at 77,
One has to be a practicing.
Muslim for 5 years before I can create a waqf. So who will decide that? I guess they will come home and ask me.
Section
3R.
3R.
Yes.
R capital or?
Small R, Malaj.
The
Exactly.
archaeology department
Correct.
being a heritage structure. Still the people can go and pray.
Exactly. So, Malaj, now the 2025 Act says, moment it's declared or it has been declared as an ancient modern community, complete takeover, including ownership, before or after.
No, but does it take away your right to practice your religious practices?
Yes. I will demonstrate to the declaration itself is void.
Are you stopped from going and praying there?
Yes, declaration of the waqf is void. It's not about whether I can, it is void.
Should we record that?
Yes, that's the third proposition.
Fourth. Sorry, third.
Yes.
On such declaration.
Yes.
As a,
On or before,
on
Malaj.
such declaration as an ancient monument.
Yes, as a protected monument
Such-
or protected area under the
For last 6 years too. But then
No, it says Ancient Monuments Preservation Act 1904.
so on such
Ancient
declaration
monuments,
as a protected monument.
yes. Or protected area.
Protected area.
Under the Ancient Monuments Preservation Act and Ancient Monuments and Archaeological Sites Act of 1958, at the time of such declaration.
Under the
and-
said act.
Yes. Yeah, and it should, Waqf property shall be void.
No, but does it also take away your right to go and practice?
Once the Waqf is void, Mullah, I can't go there. The Waqf itself, it becomes void. That's what the section says. Any declaration or notification issued under this act or under any previous act in respect of Waqf property shall be void if such property is as a protected monument or protected area. So once it is void, Mullah, how can I possibly go and...
Like, Kajura, I know because I had visited recently. Call with, now under the custody of archaeology department because all those structures are heritage. But still there is a temple wherein all devotees can go and pray.
Yes.
So therefore, I'm asking whether this declaration would also take away your right of going there and praying, offering prayers and all that.
Well, the problem is...
Maybe because it will be declared cease to be work because the maintenance and everything of a heritage structure is on a different yardsticks.
But if the Waqf is void itself, that means it's no longer a Waqf. And it's not my right anymore, Mullah. When you say Waqf is void, it's no longer a Waqf.
But is it your also? Is it your also contention that on such declaration, all religious practices which were being undertaken earlier would also not be permitted?
Manoj, it's my case that this provision is violative of 25, Article 25 of the Constitution.
Should we record that?
Yes, please, please. It's expropriatory.
Void?
Yes.
And the right of the citizens to continue with their religious practices.
That's correct. Article 25 and 26.
Their religious practices. Will be taken away.
Taken away. Therefore, it is expropriatory.
Mr. Mehta, you can ask someone to record all this.
But I am recording it. It's factually incorrect in my.
We are not asking you. We are not.
I am recording. I am recording.
You argue when your turn comes.
Yes, yes. I'll argue when my turn comes. I am recording.
We are only asking because since we are recording, we will be calling upon you to answer this thing.
Obviously, I have to answer.
The rights of the citizens to continue with their religious practices will be stopped and therefore violation of 25 and 26. So what we are recorded on such declaration under the Ancient Monument Preservation Act as a protected area. The work
monument or area.
The work will be void.
Yes.
And the right of the citizens to continue with their religious practices will be jeopardized and therefore violative of Article
25, 26 and 14, Malad, because how do you declare something to be void because the perpetuity of the dedication is lost.
Article 14, 25 and 26.
Yes, I'm good.
Yes.
Because only Muslims are tied.
Yes, sir, I know. Only Muslims, of course.
So you should have invited all of them for dinner yesterday and so that it would have been better. Now everybody is advising you here.
I forgot.
Well, that's the other important thing that your lordships will know. This is a corollary to this proposition, is that under the Ancient Monuments Act and these two acts, my right to religious worship was preserved.
So that,
despite its declaration, under the acts themselves, it was preserved.
And now it is being taken away.
And now it is taken away.
Under the said act.
No, it was preserved.
Right to religious practice of preserved.
Yes.
Yes.
Right. I mean, it says that a protected monument maintained by the central government under this act, which is a place of worship or shrine, shall not be used for any purpose inconsistent with its character. It was preserved, taken away.
16.
That's 3D, Malaj. 1 second.
Section 3D.
This is the present 2025 section is 3D. D, capital D. Next proposition, Malaj. That I have to be a Next proposition, Manoj. That I have to be a practicing Muslim for 5 years before I can create a waqf. So, Manoj, at 77,
One has to be a practicing.
Muslim for 5 years before I can create a waqf. So who will decide that? I guess they will come home and ask me.
Section
3R.
3R.
Yes.
R capital or?
Small R, Manoj.
Of the
Exactly.
archaeology department,
Correct.
being a heritage structure, still the people can go and pray.
Exactly. So, Manoj, now the 2025 Act says, moment it's declared or it has been declared as an ancient modern community, complete takeover, including ownership, before or after.
No, but does it take away your right to practice your religious practices?
Yes. I will demonstrate to the declaration itself is void.
Are you stopped from going and praying there?
Yes, declaration of the waqf is void. It's not about whether I can, it is void.
Should we record that?
Yes, that's the third proposition.
Fourth.
Yeah.
Sorry, third.
Yeah.
On such declaration.
Yes.
On
On or before,
On such declaration as an ancient monument.
yes, as a protected monument
But
or protected area. Area under the
for last 6 years too, but then
No, it says Ancient Monuments Preservation Act 1904.
so on such
Ancient
declaration
monuments,
as a protected monument.
yes. Or protected area.
Protected area.
Under the Ancient Monuments Preservation Act and Ancient Monuments and Archaeological Sites Act of 1958, at the time of such declaration.
Under the State Act.
Yes. And waqf property shall be void.
No, but does it also take away your right to go and practice?
Once the waqf is void, Mullah, I can't go there. The waqf itself, it becomes void. That's what the section says. Any declaration or notification issued under this act or under any previous act in respect of waqf property shall be void if such property is as a protected monument or protected area. So once it is void, Mullah, how can I possibly go and...
Like, Kajura, I know because I had visited recently. It's all now under the custody of archaeology department because all those structures are heritage structures. But still there is a temple wherein all devotees can go and pray.
Yes.
So therefore, I'm asking whether this declaration would also take away your right of going there and praying, offering prayers and all that.
Well, the problem is...
Maybe because it will be declared cease to be work because the maintenance and everything of a heritage structure is on a different yardsticks.
But if the waqf is void itself, that means it's no longer a waqf. Then it's not my right anymore, Mullah. When you say waqf is void, it's no longer a waqf.
But is it your also contention that on such declaration, all religious practices which were being undertaken earlier would also not be permitted?
Mullah, it's my case that this provision is violative of 25, Article 25 of the Constitution.
Should we record that?
Yes, please. It's expropriatory.
What will be void?
Yes.
And the right of the citizens to continue with their religious practices.
That's correct. Article 25 and 26.
Their religious practices. Will be taken away.
Therefore, it is expropriatory.
Mr. Mehta, you can ask someone to record all this.
No, I am recording it. It's factually incorrect in my.
We are not asking you. We are not.
I am recording.
You argue when your turn comes.
Yes, I'll argue when my turn comes. I'm recording.
We are only asking because since we are recording, we'll be calling upon you to answer this thing.
Obviously, I'll have to answer.
The rights of the citizens to continue with their religious practices will be stopped and therefore violation of 25 and 26. So what we are recording on such declaration under the Ancient Monument Preservation Act as a protected area, the work
Monument,
will be-
whatever monument or area.
the work will be void,
Yes.
and the right of the citizens to continue their religious practices will be jeopardized, and therefore violative of Article 25.
25, 26 and 14, Malat, because how do you declare something to be void, because the perpetuity of the dedication is lost.
Article 14, 25 and 26.
Yes, I'm good.
Yes.
Because only Muslims are there.
Yes, sir, I know, only Muslims, of course.
So
Don't want-
you should have invited all of them for dinner yesterday, and so that, it would have been better. Now everybody is advising you here.
I forgot.
Well, that's the other important thing that your lordships will know, this is a corollary to this proposition, is that under the Ancient Monuments Act and these two acts, my right to religious worship was preserved,
So that,
despite its declaration. Under the acts themselves, it was preserved.
and now it is being taken away.
And now it is taken away.
Under the said act,
No, it was preserved.
right to religious practices preserved.
Yes.
Yes.
Right? I mean, it says that a protected monument maintained by the central government under this act, which is a place of worship or shrine, shall not be used for any purpose inconsistent with its character. It was preserved, taken away.
16.
That's 3D, Malaj.
6.
Sorry, 1 second.
Section 3D.
This is the present 2025 section is 3D. D, capital D. Next proposition, Malaj. That I have to be a Next proposition, Malaj. That I have to be a practicing Muslim for 5 years before I can create a waqf. So, Malaj, at 77,
One has to be a practicing.
Muslim for 5 years before I can create a waqf. So who will decide that? I guess they will come home and ask me.
Section
3R.
3R.
Yes.
R capital or?
Small R, Malaj.
Of the
Exactly.
archaeology department,
Correct.
being a heritage structure. Still the people can go and pray.
Exactly. So, Malaj, now the 2025 Act says, moment it's declared or it has been declared as an ancient modern community, complete takeover, including ownership, before or after.
No, but does it take away your right to practice your religious practices?
Yes. I will demonstrate to the declaration itself is void.
Are you stopped from going and praying there?
Yes, declaration of the waqf is void. It's not about whether I can, it is void.
Should we record that?
Yes, that's the third proposition.
Fourth.
Yeah.
Sorry, third.
Yeah.
On such declaration.
Yes.
As a,
On or before,
On
Malaj.
such declaration as an ancient monument.
Yes, as a protected monument or protected area. Area under the
For last 6 years too. But then,
No, it says Ancient Monuments Preservation Act 1904.
so on such
Ancient
declaration
monuments,
as a protected monument.
yes. Or protected area.
Protected area.
Under the Ancient Monuments Preservation Act and Ancient Monuments and Archaeological Sites Act of 1958, at the time of such declaration.
Under the said act.
Yes. And waqf property shall be void.
No, but does it also take away your right to go and practice
Once
religious
the
practice?
waqf is void, Mullah, I can't go there. The waqf itself it becomes void. That's what the section says. Any declaration or notification issued under this act or under any previous act in respect of waqf property shall be void if such property is as a protected monument or protected area. So once it is void, Mullah, how can I possibly go and...
Like, Kajura, I know because I had visited recently. Call with now under the custody of archaeology department because all those structures are irrespective. But still there is a temple wherein all devotees can go and
Yes.
pray.
Yes.
So therefore, I'm asking whether this declaration would also take away your right of going there and praying, offering prayers and all that.
Well, the problem is,
Maybe because it will be declared cease to be work because the maintenance and everything of a heritage structure is on a different yardsticks.
but if the waqf is void itself, that means it's no longer a waqf. Then it's not my right anymore, Malaj. When you say waqf is void, it's no longer a waqf.
But is it your also? Is it your also contention that on such declaration, all religious practices which were being undertaken earlier would also not be permitted?
Malaj, it's my case that this provision is violative of 25, Article 25 of the
Should
Constitution.
we record that?
Yes, please, please. It's
What will be
expropriatory.
void
Yes,
and the right of the citizens
yes,
to continue with their religious practices.
that's correct. Article 25 and 26.
Their religious practices. Will be taken away.
Taken away. Therefore, it is expropriatory.
Mr. Mehta, you can ask someone to record all this.
But I am recording it. It's factually incorrect in my.
We are not asking you, we are not
I'm
asking.
recording. I'm recording.
You argue when your turn comes.
Yes, yes, I'll argue when my turn comes. I'm recording.
We are only asking because since we are recording, we'll be calling upon you to answer this thing.
Obviously, I'll have to answer.
The rights of the citizens to continue with their religious practices will be stopped